to say that, all right, we're just messing with 2% of the people. It's equally bizarre, such as the argument about the 26th of November. Oh, we didn't kill 200 people, we actually killed 12. You killed 12 people. Well, you're admitting that 4 million people are using it. You're also admitting that it used to be 8 million people before you made it impossible or very hard to access that platform without using some kind of intervening software. We don't recognize that access to what later leads to free speech and conversation is a fundamental right.
Hello and welcome to this episode of the Digi Pod. My name is Farieha Aziz. Today I'm joined by Abdul Moiz Jafferi, who is a lawyer. Recently, we read that the PTA chairman made certain remarks before the Standing Committee on IT, specifically with respect to the legality of their actions with respect to internet shutdowns and also platform blocking. And he raised something about the ambiguity regarding the legality of action and how the government orders them and they do it, and that some clarification is required from the Ministry of Law and Interior. Moiz, I want to ask you, what is the legal framework, and is there a distinction between the switching off of a shutting down of services versus platform blocking? What is it that they typically rely on, and is there a legal framework around this?
Thank you, Farieha, for doing this. I want to first of all highlight that this is perhaps something that is before the Sindh High Court as well, in terms of a challenge from the general public. Co-counsel has also challenged it in one of the ban petitions where we are challenging the Twitter ban on somewhat this premise. Basically, the law allows the PTA. So first we got telephone lines. And if you remember, in the middle of the terrorism wave in Pakistan, there was an understanding, a knee-jerk understanding perhaps, that these terrorists were using mobile networks to activate remotely explosive devices or improvised explosive devices. So the stopgap solution that was found at the time was that okay, so in any area of high risk, we will temporarily ban phone networks. And because there was no legal framework allowable at the time to ban phone networks, and obviously all the ancillary services that come with it, there was a carve-out found in the PTA Act, the Pakistan Telecommunication Reorganization Act of 1996, which is the legislative instrument through which the PTA was born. And this only came about because the PTCL was being privatized at the time. So in that, there is a national security and emergency carve-out where for certain stopgap amounts of time or for certain national security reasons, the government can suspend services or have them in a certain designated time frame be stopped as far as mobile services are concerned. And this is the PTA policy directive that is then used from 2009 and afterwards to suspend mobile networks, to suspend access to communications. There is no such similar device for the internet. And one of the reasons why the challenge to platform banning has come about is that if the government is relying on this stopgap national security arrangement, then it can't be open-ended. You can't just ban a platform. And the only way to actually stop a platform from permanently having a footprint in Pakistan is through the removal of online content and harm rules that have come about more recently. And that also envisages a tiered process where you have to converse with the platform. You have to tell it what your problems are with it. You have to tell it why, in particular, you find certain areas of it challenging, why you feel that it is being unfair in your jurisdiction. Thereafter, you have to give them a right of reply, a right to be able to put their case forward as to why they feel they are not impinging on any such rights. And thereafter, through that process, if the social media platform is intransigent, then they may be banned. Now, these are the two vehicles available. There is no vehicle available to ban the internet as a whole or to stop the internet in a particular area or for a limited amount of time. So the PTA arguably uses that same 2009 policy directive, waits for instructions from the Ministry of Interior, which tells it, all right, ban the internet for national security reasons, and goes ahead and does it. But it's a gray area because how, logically or plausibly, at least you can say that, all right, there's a terrorist threat. That's why there's an improvised electric device. That's why explosive device. That's why we need the phone lines banned. But what theory do you come up with, even on paper, to have the internet shut down. Surely there can't be an active terrorist operation on the internet. So I think that's why the chairman has had to concede that, we don't really know how we're doing it, but we are doing it. And it's up to you to find out a way to legitimize it for us.
So we see this in practice, right? That if legal authority does not exist either through an SRO or amending a law that is created. And so to some extent, you're saying that, the service suspension is one thing and the content blocking is one thing, and they rely on the rules, which also have been challenged before courts, and those are pending as well. But specifically with using a tiered approach, and there are certain things that they're required to provide, in practice, do you see that happen? And also, how tenable do you think is this, defense by the PTA that the Ministry of Interior instructed us, and so we must do it? Is the Ministry of Interior or the federal government's directives to the PTA with respect to platform blocking, are they binding?
Firstly, the carve out for the Ministry of Interior or the government through the Ministry of Interior to tell the PTA to do something is in the Parent Act. It's not by rulemaking. And it's through that Parent Act that they've made this policy directive, which I said is from 2009, whereby they first started giving legal cover to the stoppage of mobile network services. So this is a carve out that has existed for a while and has been arguably used legitimately, because there were the state wasn't able to respond to events of terrorism, and it found a stopgap solution in banning or restricting the access to mobile networks in localized areas. Um, However, because the PTA itself needs to, even through its rules and framework, it needs some form of logical excuse to come from the state before it can step in and censor or step in and block. That's why the PTA is wholly reliant upon instructions to be received by the Ministry of Interior. Now, those instructions might be farcical, as our claim is with regards to Twitter, that these instructions are violative of the law, they're violative of the policy framework, and they're violative of any rules that are in place for the PTA and for the government itself, because access to internet and access to platforms upon the internet is widely recognized now to be fundamentally a human right. And Europe, as your viewers will know, has recognized not only the internet to be a fundamental right, but high-speed internet to be a fundamental right. So, we're standing very far behind, generationally behind other countries in that aspect. And we are, as a whole, as a society as a whole, also veering towards totalitarianism and authoritarianism. And this is one of the examples of it, that, we don't recognize that access to what later leads to free speech and conversation is a fundamental right.
Now, you rightly mentioned that this digital authoritarianism that is also being referred to is on the rise in various other, and Myanmar is actually cited as an example. Unfortunately, it seems like Pakistan is heading in that direction. But oftentimes you hear officials saying, well, others do it too. And while we seek to, or the government often seeks to provide legal cover through passing laws or issuing SROs. But what about fundamental rights, and as they're enshrined in the Constitution? And like you said elsewhere, the internet is recognized as a fundamental right. In Pakistan's jurisprudence, where do you see this in terms of what we can rely on that exists, but is there more that can be created or pushed through jurisprudence or in Parliament?
Well, I don't have any hopes for Parliament, quite frankly, because they are obviously responsible for all these authoritarian moves by its regulatory arms. And this Parliament has done more to cut off democratic process than perhaps any other parliament in a shorter tenure. And if you wanted the second worst parliament, it would be the one before this one. And if you wanted the third worst one, it would be the one directly before that one. So we are on since 2013, we are on a roller coaster journey to abridge rights, because certain arms of the state and certain departments within the state feel that they need legal structure to do whatever they want to do, and they'll find a reason or an excuse if they're pushed. Otherwise, they'll just continue with business as usual. As far as these examples of other countries are concerned, fine if Myanmar does it or North Korea does it, or an Arab state does it. But those states don't have constitutional guarantees of fundamental rights. Now, if you want to pretend to be a constitutional democracy which guarantees certain rights to citizens, well, then you can't do it. And either scrap the constitution, scrap the rights enshrined therein, which which wouldn't be such a bad thing for a lot of people in this country if you had allowed them the space to do it. And the 26th Amendment is an example of certain areas of the Constitution being scrapped in the name of whatever efficiency or excuse making, but effectively denying independent judicial systems to emerge, and budding judicial independence has been nipped in the bud in the name of God knows what excuse it was, but the parliamentary debate surrounding it, it was very clear that this is vengeance against an arm of the state that has grown too big for its own good. And these maneuvers may be, in the short term, they do bear fruit because they allow. It is much tougher in today's environment to take and create jurisprudence with regards to all of these measures. But that is the only avenue available because Parliament really just wants to go in the one direction that we're all headed towards. At least that's what it looks like. So it is really up to the courts to tamper it, and it is up to the courts to enforce our fundamental rights and to declare the internet and access to the internet and specifically conversational spaces within the internet to be part of our fundamental rights, unabridgeable by rulemaking or law.
Most finally, because we hear a lot of justifications, and recently we heard the State Minister for IT saying, well, the ban on X just affects 2% and it's not really a freedom of expression issue. What in your view, is the nexus between access to platforms or internet services and freedom of expression?
Look, firstly, I find this to be a poor and bizarre argument that there's only 2%. 4 million people, you're admitting that 4 million people are using it. You're also admitting that it used to be 8 million people before you made it impossible or very hard to access that platform without using some kind of intervening software, which, half the people decided not to do. And this is a very poor argument to say that, all right, we're just messing with 2% of the people. It's equally bizarre, such as the argument about the 26th of November. Oh, we didn't kill 200 people, we actually killed 12. You killed 12 people. There should be an answerability of, even if it's not 12, even if the government is now admitting 8, you killed 8 political protesters by shooting at them. Surely there's an answer that is required there, the severity of which shouldn't be tempered by how many people you actually did this to. Similarly, if there are significant amount of people across the country using Twitter, then it shouldn't prevent a policy measure should not be allowable because enough people aren't affected. Surely that can't be the measure by which regulatory policy is created. And as far as Twitter being a platform of particular problem to these people, it's obviously because there is a horizontal method of interaction between people on Twitter. And there is an element of virality to any information that comes on Twitter, and they feel unprotected because they can't use coercion upon levers or influence within Twitter. And that's why they have, been satisfied by creating a situation where everyone is technically on Twitter breaking the law, including the federal government itself. Because using private VPNs to access this platform is obviously illegal according to our current legal regime. And the explanations for that are also equally farcical by the ministers who decide to try and talk about this because there is such little accountability for them in the public right now. I think that they've said that this is to maintain diplomatic relations with the world, that the prime minister is still tweeting. I mean, that's a farce. It's a bit of a joke. The prime minister and the chief minister belong to one family, and they're wishing each other happy birthday on a platform that is being throttled by the state that they're ostensibly in charge of. And surely there is no excuse to say that, well, they are only part of the 2% and you should keep your chins up and this is not that big an issue.
Absolutely. And this is what 2025 begins on the same note. The bans are still in place, the throttling, the services. And on the other hand, we're hearing that fiber optic cables are being laid and maybe we're getting Starlink, but it doesn't check out with all of these practices that are in place. Moiz, thank you so much for making time for DawnNews English. That's all that we
My
have.
pleasure. Thank you for having me.